welcome back to another episode of Debt Collection 101. I'm Ashley, and I have Caitlin here with Arbite as well. And we have a guest who has been on before. Everyone, I'm pretty sure, knows him. We have John Bedard with Bedard Law Group. Thank you again for joining us. We love having you on here. And we have a really good topic today. I think this is a huge topic to get out and get all the information we can to the people in the industry. So today we'll be talking or having a deep dive into the decisions affecting the debt collection industry. So before we get into the juicy stuff, for those who don't know you, which I don't think is many people, can you give us a brief background on yourself?
I'd be happy to do that. Let me first begin by thanking you for having me on today. It is always so much fun to be with you at Arbite, and so thank you for inviting me back. My name is John Bedard, and I'm an attorney here in Atlanta, Georgia. Our firm represents debt collectors, debt buyers, creditors, and attorneys, and we help them stay in compliance with the myriad of laws that regulate their businesses around the country. We also help them with their defense litigation around the country when they get sued by consumers or when they get sued or investigated by the government. And so that's what we do here in Atlanta. We represent clients all over the country, and we're delighted to represent Arbite customers as well. So thank you.
Thank you.
So John, I think so many people in the industry are really familiar with what's happening, but just in case, for those of us who may not be as familiar, may not be seeing up on the news, can you just give us a little context on why this new TCPA decision is so significant and, what was at stake when it first came into the Supreme Court?
Yes, and so I call it the Facebook case, Facebook versus Duguid, which is a recent case out of the U.S. Supreme Court on the TCPA. And, very briefly, what happened here is a Facebook user signed up for Facebook and provided Facebook with their cell phone number. And one of the features that they took advantage of was a new security feature that Facebook had that would send users a text message when Facebook believed that somebody was signing into that account from a device that Facebook didn't recognize. It was a security feature. Well, lo and behold, that Facebook user abandoned that telephone number. They no longer use that telephone number, and the carrier assigned that telephone number to somebody else who was not a Facebook user. And what was happening is that second person with the telephone number, the plaintiff in this case, Duguid, began receiving text messages from Facebook because of the login information of the original Facebook customer. And of course, they didn't ask for that. They weren't even a Facebook user. And so they got upset about it because they didn't have a way to stop those text messages according to the case, their complaint. And so they filed a lawsuit against Facebook saying, hey, you're sending me text messages without my permission, and that's not allowed here in the Ninth Circuit, which is out on the West Coast. And so quite literally, the plaintiff won that case. The Ninth Circuit, the case got up to the Ninth Circuit Court of Appeals. The Ninth Circuit said, yeah, you're right, plaintiff. They shouldn't be sending you these text messages. And so Facebook appealed this case to the U.S. Supreme Court. And so the U.S. Supreme Court had to interpret the TCPA, specifically interpret the definition of automatic telephone dialing system, because Facebook's argument was that the TCPA regulates the use of an automatic telephone dialing system, but our machine, according to Facebook, is not an automatic telephone dialing system because it does not contain or use or even have the capacity to randomly or sequentially store or produce telephone numbers and then dial them. And so that was the issue that the Supreme Court had to undertake, which was to determine whether or not a random or sequential number generator was necessary in order for a machine to satisfy the definition of automatic telephone dialing system. And lo and behold, the Supreme Court answered the question, yes. In order for a machine to be considered an automatic telephone dialing system under the statute, it needs to have the capacity to store telephone numbers store or produce telephone numbers using a random or sequential number generator, and then to dial those numbers. And if the machine does not have the capacity to do either of those things, to store numbers using a random or sequential number generator, or to produce numbers using a random or sequential number generator, then the machine is not an automatic telephone dialing system, and the behavior is not covered by the TCPA. And that's ultimately what the Supreme Court found in this case, that the definition required the use of a random or sequential number generator. Facebook's machine did not have that, and therefore the plaintiff did not win the case. The plaintiff did not win the case, and the decision of the Ninth Circuit Court of Appeals, which found that the plaintiff should win, got reversed. And so that's sort of this case in a nutshell. That's the Reader's Digest version of what happened in this case.
There's so much to this case, and I know it happened a couple weeks ago or a few weeks ago. I'm still learning about it, and it's just crazy to think that this is, the definition is like different almost, or they're actually taking it very literally. And curious to see how in the future this holds up across everyone.
And here's the thing that I think should be reassuring to everybody about this case, is that notwithstanding that many, many judges and many, many courts around the country have interpreted this statute incorrectly for many years, basically the Supreme Court went back to basics and said, look, we begin interpreting this law by reading the words. We have to look at the words to determine what they mean. Words matter. Importantly, punctuation matters. And so when we read this definition of automatic telephone dialing system, I'll spare you the semantics of all of the interpretation, but the court says, look, the comma matters, these words matter, the word or matters, the word using, when it says using a random or sequential number generator, matters. And so we're not going to read any more than this. It's clear what it says, and we don't have to look anywhere else to determine what this means. And I think that is a reassuring approach, because it's really dangerous when courts and judges begin to interpret laws by looking at things other than the actual words that they need to interpret. And so finding meaning in a statute begins by reading the words. And that's what the Supreme Court did. The Supreme Court said these words are clear and there's no reason to go elsewhere. And that's how they came up with this decision. And I'm reassured by that. And I think it should be a message to courts and judges all over the country to say, look, this isn't this isn't an opportunity for you to decide what you want the rule to be. Just read the words. Right. And so that's how this decision came down.
Yeah, geez, so much information. So we kind of covered how they arrived at that decision. So now the general conversation seems to be that human intervention is no longer a key piece of a compliant auto dialer, ATDS. Is this true? And do you think this narrowed definition is sustainable?
So I don't think the entire opinion uses the phrase human intervention at all. I mean, somebody's going to check me on that and send me an email, but I'm not remembering that phrase in there at all. And I do think it means that human intervention is not a relevant consideration when determining whether a machine is an automatic telephone dialing system. This whole concept of human intervention was created by the Federal Communications Commission when they were creating rules to implement the TCPA, or more accurately, when they were issuing declaratory rulings on petitions that were filed before the FCC. And so this concept of human intervention is really a product of the FCC's imagination, which I think is no longer, it's confirmed now that it's no longer relevant when we're determining whether or not a machine is an ATDS. Now, you referred to this definition as narrow. which sort of has a connotation to it as negative, and I want to make sure that we don't make a negative connotation. The definition is what it is, and I think the Supreme Court got it right. Whether we call it narrow or we call it broad, they read the words, and the words have their plain meaning, and it means what it says. And so, is it sustainable? I think the answer is yes, because the Supreme Court's the final arbiter of what this statute says, and only the Supreme Court can change that now. And I'm not anticipating that this issue is going to be before the court again anytime soon. That's for sure. So I think this is the definition that's here to stay for a while.
Yeah. I mean, I agree with everything you said. I think it's so great to see that these courts are kind of having to, go back to basics and just look at the language in there and make their determinations based off of that. And I think it's so funny, when this case first got proposed to the Supreme Court so many months ago, I remember Mike Gibb over at Accounts Recovery had this great article, and the headline was like, is it all going to come down to a period or a comma, which, it ultimately did. It's pretty funny, but kind of getting away from that human intervention. I know when I first saw the case come out, I was, I instantly was super happy, like, okay, the TCP is gone, but I don't think that's, a good way to look at it, because it's not gone. And a piece of that I think not a lot of people I've heard talk about, but it still exists there, is that aspect of pre-recorded messages. So do you have any thoughts on that, and just like, what agencies should be taking into consideration if they are still using those pre-recorded or artificial voice messages?
Yeah, that's a really great question. And so it's very important for listeners to understand that this Facebook case did not in any way address the issue of pre-recorded or artificial voices. And so if somebody is using a pre-recorded voice or an artificial voice, then they are going to have to make sure they still comply with the statute when the statute talks about restrictions on using pre-recorded or artificial voices when dialing cell phone numbers. And so those restrictions are still in place. This case does nothing to change that. And so it's a proceed with caution when it comes to, one, dialing in general. This case does not allow people to overdial, right? We still have to avoid harassing, abusive behavior. And we have to make sure that we are still complying with all of the rules surrounding artificial and pre-recorded voices.
Yeah, so I think good advice is to get legal advice before switching up anything and just starting to use an ATDS again. I know after this ruling, I had a few clients reach out to us and ask about this, as far as, well, doesn't seem like the TCPA is there. Can we use like a broadcast now? And it's the TCPA is still there, and you have to just take the necessary actions to follow those rules still.
Correct. No doubt. No doubt.
So that was a lot of information on the TCPA Facebook case. And I think that's really good. And this is kind of last minute for us. Obviously, we had talked about this before we started filming, but the big thing now is the Hunstein and Preferred Collection and Management case, as far as sending letters now. So we wanted to touch on that just a little bit, and just give us, if you can, just give us some background on that, and what the outcome was on that case.
Sure. So just yesterday, the 11th Circuit Court of Appeals came down with a decision in a case in which the debt collector was accused of engaging in an unauthorized third-party disclosure in violation of the rules of the FDCPA, which says that a debt collector may not speak with any person other than a specifically identified list of people about the debt. Debt collectors, the jargon here is third-party disclosure. And the context of this case is that the debt collector was using a mail vendor, a letter vendor, to send letters to consumers. And this particular consumer accused the debt collector of sharing information about the debt with the letter vendor, who then took that information, populated a form letter, and sent it to the consumer. And some important holdings from this 11th Circuit Court of Appeals was that the court concluded that that was a communication under the statute, under that definition of communication. In fact, both the plaintiff and the defendant conceded that what the debt collector did was engaged in a communication with the letter vendor. But more importantly, the court found that that communication was, quote, in connection with the collection of a debt, end quote. And the significance of that is that if the debt collector engages in a communication in connection with the collection of a debt with a person who is not one of those specifically articulated permissible third parties, well, then the court found that the plaintiff stated a claim against that debt collector that could potentially become a violation of the law. And so that is that's a significant holding because it has never before been believed by debt collectors for decades now that using a letter vendor to dispatch communications to a consumer could potentially violate the law. I know there are a great many debt collectors in the marketplace who do use vendors, not just letter vendors, but lots of other vendors that they share consumer information with. And this case potentially raises some questions about whether that is lawful. Now, it's important for everybody listening to understand that this case is not over. It is not over, and it's not going to be over for quite some time. So it's important to take a deep breath. It's important not to panic. It's important to be thoughtful in your approach on what to do with this now. And it's also very important to be talking to your own legal counsel about what you should be doing now, if anything, in response to this case.
Yeah, I think that's great advice. Always just take a deep breath. I know, again, we saw this come out and instantly it kind of throughout just our organization is like panic of what is going to be the next step for this. And if we're all kind of looking into our crystal ball right now, I don't think anybody has the exact answer of how this is going to turn out. But, I know for me, like one of my initial concerns, like you said, right now we're looking at this in the scope of a letter vendor, but like, do you think that this could expand out to other vendors and to take it a step further? Like we're, again, looking in the scope of the 11th Circuit, do you see this going out to other places? I think like New York already picked it up. So I guess just overall, what are your thoughts of how this plays out if you're taking a guess here?
Well, the court specifically put in its opinion, this court says, look, it's not lost on us the significance of what this means for the collection industry. The court goes on to say, it's going to mean that debt collectors have to print letters in-house. I mean, literally, this is right in the opinion. And the court also acknowledges that this decision may affect more than just letter vendors, but other vendors that debt collectors use in their collection processes. The court seems to understand the significance of the decision and the impact it will have on the collection industry, but nonetheless declares correctly, I might add, that it is bound to read the law and it is bound to interpret the law, notwithstanding the consequences that it might have, and that its reading of the law leads the court to the conclusion that it reached. And so, although I appreciate that the court remains faithful to the language of the statute, which is what we want all courts to do, by the way. I do think that this case is maybe subject to being vacated or at least revisited by the court. There are some really good reasons why the court may have gotten it wrong. I expect what will happen in this case moving forward is that the defendant in this case will ask the court to rehear the case. If that is granted, that will be good news. The court will look at this case again freshly and hopefully reach a different conclusion. If the court denies the defendant's request to rehear the case, then the last stop is the U.S. Supreme Court. And this defendant will then have an opportunity, if they choose, to request that the Supreme Court hear this case. And we'll keep our fingers crossed on whether or not the Supreme Court would take the case. I don't have the answer to that. I don't think anybody does, but that would be the procedural next step. And then if the 11th Circuit denies the request and the Supreme Court denies the request, well, then this decision is here to stay in this case, and It goes back down to the district court for more litigation. This case is not over by any means. It will not be over for a long time unless it gets settled. And I do think there's still a path to victory for this defendant.
Yeah, this is so much, again, so much information, and it's so new. I think it's good that the people watching know that it's far from over. There's a lot of things that can happen with this case. And I had a quick question, and correct me if I'm wrong, but this, I mean, what's being tried? I mean, that happens pretty frequently in our industry, right? Where you use a letter vendor, have to provide this information to send the letter out.
Yeah,
Right.
it's not uncommon for a debt collector to use the services of a letter vendor
Mhm.
to reduce cost, to increase accuracy, to create efficiencies in ways that they can send, communications to consumers. In fact, there's enormous consumer benefit from a debt collector's use of a letter vendor. This case does nothing to protect debtor privacy or anything like that, in my view.
Yeah.
There is very little risk to privacy when we use vendors to give us services better, faster, cheaper, because in the end, it's the consumer that is ultimately, um, paying for all of these services.
Mhm.
I
Yeah.
actually, I actually
Okay.
had a question as well going off of that. So, kind of again, just thinking into the future, I don't want to say that this is like an opportunity for a good thing, but like, do you see any potential for this to be a place for maybe agencies to look at services like email or like texting or different technologies, and maybe instead of having that traditional letter vendor, go to something like that for those services?
Well, there's a sense in which the answer is yes, but the thing that's concerning about this decision is that it is not difficult to take the analysis of this decision, to take the logic of this decision and apply it to many other applications. You mentioned email vendors. Why couldn't the analysis or the rationale of this case be applied to an email vendor? Why couldn't it be applied to a text message platform? Why couldn't it be applied to anybody with whom a debt collector might engage to dispatch communications to consumers? And the court says in the decision that it understands the magnitude of what it's holding. The court also admits that it probably does very little for consumer protection to reach this conclusion, but nonetheless, the court specifically states correctly that it is bound by the rule, by the words of the statute, and this is the court's interpretation of those words. And therefore, notwithstanding that it doesn't really do anybody much good to reach this conclusion, that's the conclusion the court reaches.
Yeah. Well, that's all of our questions. I think these two court cases are huge right now, and of course, with the Hunstein one, this is brand new. So I'm sure we will be keeping up to date. I already know you have so many talks going on about it. So anyone who's watching this, look out for any webinars or anything that John's on, or any other attorney in our industry. I think all of you guys are going to have great input on it, and I think it'll be very beneficial and helpful for the agencies who are very nervous about it. I think after going through all of this, though, a lot of it seems to be good. Hopefully, this case turns out the same way. But like you said, it's far from over. So hopefully, it's all good news. Um, but thank you again. I'm sure a lot of people are going to get great information from this. And if you have anything else to add, let us know. If you want to maybe put where people can reach you. I'm sure a lot of people
Oh,
might have
sure.
questions, but yeah.
Sure. Well, thank you for that chance. You can reach me at my email address, which is jbedard@bedardlawgroup.com. My phone number is 678-253-1871, 678-253-1871. If you want to visit our website, it's www.bedardlawgroup.com. And at our website, all of your listeners can learn about our monthly service retainer compliance service, which we call BLG 360. And so it's an unlimited amount of compliance services that our clients receive when they enroll in our monthly BLG 360 plan. It includes letter review, it includes all kinds of stuff, and they can find out more about that at our website, or they can give me a call or send me an email.
I appreciate that, and I'm sure everyone watching does as well. So thank you again for going over the two biggest topics in our industry right now, and I'm sure we will see you back on here sometime soon.
My pleasure. Thanks so much for having me. Bye-bye.